family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, we are on our new time now. We're on from 6 to 7 on Thursdays and Mondays now. You can catch our show on 1470 AM, 103.9 FM, 96.9 FM, and 95.3 FM. Almost got them all. This is the first Thursday of the month, which means we have our Community Association show on K. Bender Rimbaum. We have about 20 shows. This is the easiest show to do. We love getting your phone calls, and we have one of the senior partners whose name happens to be first, K. Bender Rimbaum. Hi, Robert.
Hello, Steve.
Our
How
new
are you?
time. It is so dark outside.
I hope some of the people followed us here.
Listen, if you have a question, you live in a condo or you live in a HOA association.
Even a co-op.
Yeah, even a co-op. Give us a call here at 888-565-1470. We have been doing this for about the last 3 years. You opened up a new office in Tampa.
We did, yes, in April of this year, and that's picking up clients every day, so
Well, you've got a great firm.
Thank you.
One of the largest in Florida. And I got to tell you that I know there's a lot of new listeners that are joining us for the first time. Tell everybody about your firm.
Well, K. Bender Rembam has been continuously providing services to community associations since 1992. Started out in Fort Lauderdale and moved to Pompano Beach, now with an office in Palm Beach Gardens and, as you just mentioned, in Tampa. The primary focus of our practice is community association, handling all aspects of the day-to-day affairs and any litigation matters that may come up, from dealing with review of the documents, determining the rights of individuals, rights of the association, providing the opinions of that, assisting in contract drafting negotiations, dealing with violations, dealing with contract disputes, dealing with construction defects, collecting assessments, pretty much everything that an association deals with on a day-to-day basis.
You know, if you're on your computer now, you could actually watch this show. Watch this show live by going to www.kbrlegal.com. That's your website.
Our website.
They can actually go and watch the show live right now for the next hour. And we do all kind of things on this show.
And it's also there throughout the month and beyond.
And, you know, you've got really a great website. Somebody looking for really good information. You've got, like, I love the morsels. That's
Legal Morsels.
Legal Morsels.
Under the resource tab, we have Legal Morsels and Rembam's Association Roundup with articles of topical interest. The Rembam Roundup does tend to have more articles in it because he just pumps them out, but Legal Morsels is a little more selective
full of
in its
information.
topics. Yes.
It's amazing. I'm so glad you do take care of your website. Some of them don't. But if you'd like to call us here, you can give us a call. If you have a question for Robert, it is 888-565-1470. And what we also do is people email us questions, which we ask Robert. And I guess we had a lot of good questions this time because there aren't very many lines tonight.
Let's not burn through them too fast.
Yeah, we're going to get a lot of calls during the show. We're on for the next hour. Again, this is our new hour, 6 to 7. Tell all your friends about it, and especially if you are a board member, maybe you have elections coming up, and you have a question, give us a call here, 888-565-1470. And you've got some classes this month.
We have some.
Not as many as usual.
It's a smaller schedule, mostly Pompano Beach. Pompano Beach has one course this coming Tuesday, December 10th at 6:30 to 8:30. It's the Condominium Board Member Certification course. That one's an important one for condominium board members needing to be certified either before or after their election. It's also being taught in our Palm Beach Gardens office on Wednesday, December 11th at 3 o'clock in the afternoon from 3 to 5:30. Then on Wednesday, December 18th in Palm Beach Gardens, the HOA board member certification, 3 o'clock to 5:30 p.m. And then Wednesday, December 18th, being a doubleheader at 6 o'clock in the evening, board member and officer liability insurance policies. You think you're covered, think again. So that's an important topic for all board members, dealing with making sure they're protected by their officer liability insurance.
There is so much that the board needs to know. It's like almost like running a big business.
Well, it is exactly that. They are running a business. Many have budgets in several hundred thousands of dollars a year into the millions of dollars a year. So they need to be prudent in the way that they do their business. They are supposed to spend the money, but they're supposed to spend it wisely and correctly. They have what's called a fiduciary obligation to their membership to put the interests of everybody ahead of their own personal interests. So these are important things that they would be learning about.
And you know what? The best way, if you feel like you've got problems with the association, run for office.
Well,
get
that's
in there.
Certainly one way. Before you just jump into running for office, it's a good idea to attend board meetings. Hopefully they're having them regularly. See what's going on, see the processes. You're, as an owner within, you're entitled to speak during the meetings about the issues that the board members are addressing. Some may have rules limiting when and how you do that, but it's still an option that you are supposed to be provided as an owner to give your opinion. They don't have to follow your opinion, but that could be why you'd want to run for the board, is to make sure your opinion is given more weight.
Well, let's get started with some questions. Again, give us a call here. We have lines open at 888-565-1470. This is the Ask the Expert show. This is our first Thursday of the month, and we always have Kay Bender-Rimbaum on with us. Let's start off with Kim from Boca. Why is it condo owners have more rights than HOA owners?
Well, I
And
don't
they want to
know
know
that,
about warranties too.
I don't know necessarily that they have more rights. It's the condominium statute has been in place since 1965 and has been modified and expanded, and it's grown through the years. And these rights that condominium owners are referring to are contained in the statute. On the HOA side, that statute didn't come about until 1995 and has far less in it. Developer warranties is something that HOA statutes do not have. Condominium statutes have significant rights and obligations set forth on developer warranties, and that's been in there for probably close to 50 years. So it would be
Condo
helpful if
associations have
HOAs
been around longer than HOA.
I don't know that I'd say they've been around longer. I think it's more they've just been statutorily controlled. They're different in the technical way that they're created. A condominium only exists because the statute provides for it. And in essence, a condominium, what you own is airspace within the unit, and the building is mostly common elements. In an HOA setting, you own the land and you own the buildings on the land, and it's more typical of the type of ownership of real property. And so there was no need for extensive legislation, at least initially, as there would be for condominiums. Because of the difference of the type of ownership, then the condominium statute evolved as it did. HOAs, you have your documents, You have some provisions in the statute, and every year they tinker with it and try and add to it. And it's a whole political process up in Tallahassee that sometimes they're successful, sometimes they're not. Like last year, nothing really was passed to make much change in it. So, that's the nutshell reason why they're different.
Okay. The next question is from David in Pompano.
Hey, David.
He lives in a condo. This is what we were talking about before. The security cameras in the parking don't cover all the cars. They installed the cameras over 10 years ago. Do we need a vote from the members to add more cameras?
Well, that's going to also depend on your documents. This is really more a condominium issue than it is an HOA issue, because within the condominium statute, it provides that you're not allowed to make material alterations or substantial improvements to the property except as provided in the documents. And if the documents are silent on the issue, then it provides for a vote of 75% of the unit owners. Most condominium documents do have some provision that identify whether or not the board can do it on its own. Sometimes they'll put a dollar figure or a percentage of their annual budget of what they can do without a vote of the owners. And there's various formulas that you could run across. So you need to check your documents first to see what limitations there are in material alterations. Adding cameras where there are none would likely be considered a material alteration based on the way the case law developed through the years. It's fairly wide range of things. Unfortunately, the division of condominium has gone beyond what the case law really has done in creating certain standards that most people have to follow to avoid a problem from that agency, such as the change in the color of the paint on the exterior of the building, or even interior things that change color has been considered a material alteration by the division by not quite understanding a case that came out in the late 70s. In any event, that's the status. So cameras, even though you have cameras, if you need more cameras, the chances are you may need a vote, but you need to check your documents to see.
What if something happened in the parking lot there where there weren't cameras? Who's liable?
Well, it isn't a matter of adding liability for not doing it. In a situation where there's been an uptick in criminal activity or vandalism and things of that nature that makes it a security issue, there are exceptions in the case law that allow for the material alterations to be made without an owner vote, even when the documents require it, if the change is required as what we would call necessary maintenance. And security type issues with documented situations going on in the neighborhood has been identified as one particular reason to use to not have to follow the requirement of what the documents say.
Okay.
So it's possible in this setting, but we don't have enough information from David, and he's not on the phone to tell us. So that's one good reason to call in with your questions.
We're going to go to break. The phone number here is 888-565-1470. Give us a call if you've got a question about your association, and we will be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
4-second video.
We're back. This is the Ask the Expert show. If you don't know, if you're driving in your car right now, because we used to be on at 5 o'clock, and now we're going to be on from 6 to 7 every Thursday, and now every Monday from 6 to 7 here on 1470 AM, 95.3 FM, 103.9 FM, and 96.9 FM. 4 stations now. I mean, we are covering Palm Beach and Broward, and this is the first Thursday, so we always have, which we had for the last 3 years, K. Bender Rimbaum. They're a community association law firm, one of the best firms. I'm telling you, if you're the president of your association and you have a law firm, you ought to call them up. They are amazing. They have probably some of the most associations here in South Florida, and people love calling in, asking questions, and you do a lot. You give back a lot too. You have a lot of these classes.
We do.
The one I like the best is the Ask the Lawyer.
Ask the Attorney. We don't have one scheduled in December. It's a tougher month for getting people to attend, but we have one January the 9th scheduled in Boca Raton. That one's going to be at 11 o'clock. We'll talk about that in greater detail next month. It's Thursday, January the 9th. I think it's in the South Delray Community Center over there on Powerline. I think it's Powerline.
So you've got that. And then also, we want to remind, if you just tuned in and you're at your computer, you can actually watch the show live by going to kbrlegal.com. That's K. Bender Rimbaum's their website. You can actually watch our show, or you can go back later, and all the shows are up there. Give us a call now if you've got a question about your association, 888-565-1470. What we're doing right now is we get so many questions for Robert, and it's amazing how so many people are writing now. Every week, we average probably anywhere from 20 to 25 emails, and we try to pick out the best. The next one is from Macy in Hollywood. I love your show. Nice. It's so informative. Many of our members, our board members, also listen to you every month. We have some owners that are really causing problems. You and I were just talking about this. She said, can we suspend owners' rights, take away certain privileges if they keep causing problems? I think I know the answer to this.
The answer to that is yes. There are things that can be suspended, use right-wise, but you can't just do it. You have to follow a procedure that the statute provides for in Section 718.303. Within that statutory section, they require that there be notice of the issue and a hearing before a committee of non-board members to... You
have a hearing of non-board members?
It's like an internal type of tribunal of sorts to determine that it's something that should be suspended. There are limitations on what can be suspended. You cannot suspend somebody's ability to come in and go out. The ingress and egress, you can't suspend utilities. So access and utility and parking spaces, you can't mess with those. But using the recreation facilities, if you're going to suspend use rights, it's important that you're able to enforce that suspension. So if you don't have a way to limit somebody's access into the area, we don't recommend that a board member stand at the door and bar someone from coming in. It's not a good idea to put yourself into harm's way. But if you are able to limit access through like a key fob or specific locking section, then that might make it a little easier for the board to do. One that we were talking about before is some communities have dual access gates where they have one for the residents that's automated and everyone else comes through the manned gate. Suspending the use of the automated one is a good method. More often that's used when someone isn't paying their assessments.
Okay.
But for violations of the covenants, that could be used as well. And then they have to go through the man gate, which is inconvenient, but they still have access.
Just off the top of my head, because actually I got this on the way over here. Somebody wanted to know if your firm, they just got I guess it's called a turnover from the developer,
Yes.
and they wanted to know if your firm would assist them in the types of questions to ask people, renters that are going to be coming in,
Well,
to make sure
certainly
they
yes.
cover all the bases.
The answer is yes, but it's important for new board people to understand, particularly after turnover from the developer, that there are things you have to be careful about when you're dealing with approvals or disapprovals of renters or of sales to new buyers. Asking questions, I'm assuming they're referencing maybe in an interview process
Yes.
as opposed to on an application. It's better to do everything by application in writing. The personal face-to-face interview is one we recommend to be more of a, once you've been approved, let's get acquainted with the board, here's the rules, here's more of a meet and greet than
So
an
the
interview.
application is probably
The
more
application
important.
is the better method because it's more objective and neutral. If you meet someone face-to-face and you disapprove them for whatever reason, the chances of a claim of discrimination increases dramatically because now you've seen them, you know what their ethnicity is, and so whether or not it was a factor doesn't matter. It just becomes an issue that you have to deal with, and that can be time-consuming and expensive. And it's not something we recommend board members handle without legal assistance because the pitfalls are great, and you can find yourself with civil fines of $10,000 or more on
Wow.
a discrimination claim. So it's not something you want to take lightly.
Well, with all the construction that goes on down here in South Florida, I bet you there's all kind of turnovers
Oh, yes.
that happen. And I'm sure it's different for HOAs than it is condos.
It definitely is, yes.
Okay.
The HOAs, usually the common facilities are going to be just different. They're not as involved. They're not necessarily as large of a dollar item at issue as it would be in a condominium where the whole place is a common element and maintained by the association. So issues between developer and owners on turnover are quite different in a condominium.
I know we have a question here somewhere with all of our questions. Someone was actually talking about the turnover, and they say that the developer owes a lot of money. What do you do in that case?
Well, that's a problem.
Yeah. So isn't there a way to, this is taken care of before the turnover is actually done?
Well, it's supposed to be, but really depends on the facts and circumstances. When there's a turnover from a developer to the owners who are not developers, it's important that the association and the owner board immediately undertake a financial review of the books and records of the association, as well as bring in an independent engineer to do a complete study of the physical complex and get with competent counsel familiar with the area of law to make sure that all of the issues that are available to be addressed are addressed and pursued appropriately. Most developers set up separate corporations to develop new places. So the possibility of looking into deep pockets sometimes is non-existent. So that's something else that has to be evaluated, is whether the association should be spending tens or into $100,000s of dollars to pursue a developer for bona fide claims when the developer is basically judgment proof. So
Turnover's based on occupancy?
it could be occupancy, it could be time from the CO. There's a formula that's set forth in the statute.
Well, let's go to our first call today. It's from Jack. Hi, Jack.
Hey guys, how are you both doing?
Good.
Doing good.
Do you have a question for Robert?
Yeah, I've been born. My uncle lives in a large scale condo in Coconut Creek, and they're thinking about raising revenues by opening their large theater to the public. And he was wondering about some of the legal concerns. What would be some of the primary legal concerns with opening up what was primarily a resident-only facility to the public for shows and movies and stuff?
Well, the first thing is that once you open to the public, you're now subject to the Americans with Disabilities Act, which is far more involved and intrusive to a condominium association than it otherwise would be, relative to making sure of handicap access and a number of other items throughout. We're talking not only access, but the bathrooms, and throughout the facility there's a higher level of requirements and regulations that have to be followed, which can get into significant cost. And in a condominium, while there are other requirements under fair housing laws, the requirement of retrofitting is not one of them. But if you're suddenly making the facility available to the public, the likelihood of the requirement of retrofitting is very high. So that's the largest issue of concern in switching to that. Obviously, there's liability issues of bringing in outsiders for potential injuries, so you got to make sure there's sufficient insurance in place to cover the association and the membership from what could be extensive exposure for claims as well. And if there's theaters and shows, then there's licensing issues with the materials that are being shown and royalties that have to be paid. Even in the private setting, that's an issue.
Right.
So you have to be aware of that as well.
But how is it, I mean, what about the invited guests? What if your invited guest happens to be somebody with a disability? I mean, technically that's somebody from the public, so does that not count if it's an invited guest with like a resident guest pass or something of that sort?
Well, an invited guest would fall under fair housing, not Americans with Disabilities Act. The Americans with Disabilities Act only applies to facilities that are open to the general public. And if you're inviting a guest into your private residential community, that's not the same thing.
So it almost sounds like it's not even worth it, that the potential revenues from larger audiences would likely be canceled out by all of the insurances and such that you may be getting into, plus the construction.
No, that's very possible, but I guess they would need to do a complete budget as to what they're spending versus what they think they can bring in.
Okay. Interesting. I will definitely fill them in. Thank you very much for that.
Thanks, Jack.
Appreciate y'all.
Hey, thanks for calling.
Hey, we got to go to break. When we come back, if you'd like to give us a call here, it's 888-565-1470. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum. a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680. You are listening to the Ask the Experts show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 5 to 6 p.m. Now, get ready for more Ask the Experts.
We are back. This is the second half of the Ask the Expert show.
New time.
New
same
time,
day.
6 to 7. So you have us to drive home with. The very first show each month is the K. Bender Rembaum Community Association.
On Thursday.
On Thursday, because we're also on Mondays now, too. And we're just kind of going through these questions. And, again, we have a lot of new people who are tuning in for the first time that don't know about K. Bender Rembaum. So we always like to, in the second half of the show, go through it again, telling people about your firm, which you should be very proud of.
I'm proud of our firm. We've grown from nothing to the 3 offices that we are currently in with 19 attorneys. And
you're known for your service.
Service
which is so important.
Very important, yes. Providing a personal response and an understandable response in a timely and a cost-effective manner is basically how we operate, and at least we always strive to. We're not perfect, and sometimes things are so technical that they can't be avoided in staying technical, but making these issues understandable, because our clients as board members are not necessarily experts and well-schooled on a lot of these things. They have other things in their lives that they do. This is a volunteer position. It's not their profession. So we understand that they need to sometimes have things made more layperson friendly, and that's our goal. We strive to do that. We've been continuously providing these services in this area since 1992. And as I say, I've grown into the 3 offices: Pompano Beach, Palm Beach Gardens, and as of this year, Tampa. And we do cover other areas from those offices throughout most of the southern half of the state and up as far as Daytona. So, these days it's easy to communicate and have access to the legal advice that we provide. We don't necessarily avoid calls. We have a person who answers the phone instead of a machine that loops you through voicemail to voicemail. It's our policy to respond to all calls, emails the same day, if possible. Obviously, if it's late in the day, it might not happen until the following day.
Right, but you hear about people who try to get a hold of their lawyer and 4 or 5 days later, they get a call back.
You may not get an opinion that same day on a complex issue. It might take a few days, but we don't let things sit. And we've heard from so many of our clients of other attorneys that they can't reach for weeks and even months on things that should be relatively simple.
Listen, when you've got a problem and you don't know what to do and it involves a legal problem, it's nice to know that you might not get a call back the same day, but probably pretty sure the next day. And that's so important. But I know how important customer service is with your firm.
Absolutely.
And
it's hard when you're getting 200 and 300 emails a day.
Yes, yes. So, but we're telling people what your firm does, because sometimes there's new people out there, new board members that are listening to the show.
All
now.
aspects of community association operations is the legal advice that we provide, from reviewing the documents on issues of responsibility to maintain, or providing opinions to the board as to their responsibilities and pursuing violations of various residents, be it through their actions or their failure to pay the assessments in a timely fashion, dealing with third parties, contractors, and contract negotiation and completion, as well as contract disputes and construction defects, dealing with city issues, ordinance claimed violations, and things of that nature, administrative issues, dealing with the division of condominium and arbitration issues, handling everything that an association will deal with on a day-to-day basis.
Wow. I mean, for someone, I'm a layman here, but I am in an association, but I would think you would want to have a law firm that is there for you. And because there's so much to know when it comes, especially the ones that have these $1 million budgets, there's a lot to know, and you got to protect yourself. So I don't even know why an association would not have a reputable firm representing them.
Well, one thing that a lot of associations tend to do is when they have outside management, they think, well, managers in the business and they must know what the law is. But one of the problems are managers are actually precluded by the Florida Supreme Court on a number of decisions through the years from providing legal advice to their condominium homeowner association clientele. So it's imperative that the associations be getting that advice from a qualified attorney, not from a property manager.
Give everybody your phone number.
We haven't mentioned that once today. 800-974-0680.
And your website?
Website is kbrlegal.com.
I want to find this because I was like, someone wrote us about the trees. Trees, they can actually, the county can tell you where you can plant trees, or that you have to have trees. I've got it on here somewhere that actually a lot of the residents 20 years ago did not like the trees, and they took them out.
Huh? Well,
and then they're being told now.
Every city has their own ordinances about tree placement and replacement. Every development plan that goes through approval from the city and the county will include trees and have a specified number. And if a tree is removed, it's supposed to be replaced. Now, there is some new legislation that went into effect this year that takes that away from the municipalities, and that the associations no longer are required to follow these edicts from their local municipalities. I don't know that that's been tested in the courts yet. So
why do they get involved with that?
Who, the cities?
Yeah.
Well, they have an idea of how they want their communities to look, and I think it's been the philosophy through the years that trees and foliage are important in creating the appearance that they want to within. So we don't want to be a concrete jungle. We don't want to look like, just rows and rows of the same type of construction and get a tenement type feel. The personality and a charm and a feel. So that's the philosophy over the years, and some communities are more involved with it than others. I understand Coconut Creek through the years has been very diligent and strict. Coral Springs, just to name a few. Certainly Pompano Beach is always interesting to deal with. Plantation as well. It can be, yeah.
They said they had 300 units.
And there has been, through my time in doing this work, that if you're removing trees in the community, you got to get a permit, and in that permit, you've got to identify the trees you're taking out, and then you've got to identify the trees that you're replacing them with. And there's certain diameters of tree trunk that has to be replaced. You wouldn't have to necessarily put the same tree in the same place. You can put them in other places, but they want you to make up what you've taken out.
Wow. It's amazing. Here's one. This is from John and Delray. Change in governing documents on rentals. Can we do this by just changing the rules?
Well, we don't know if John's a condominium or an HOA.
Yeah, it does not say.
But typically, if you're making a change to a use restriction on the property, you're going to want to do that by an amendment to your declaration of condominium or declaration of covenants, as opposed to just making a rule. For a rule to be enforceable, the case law through the years have created a 3-level test that has to be satisfied. The first being that the association has to have the authority to make the rule in the first place. So you have to look for that. And assuming that that's there, then the rule that you adopt cannot be in conflict with either something that's expressly in the documents or something that's reasonably inferred from the documents. And if the documents are silent on a topic, the presumption is that it's unrestricted. So, for instance, you have nothing in your documents about renting. If to adopt a rule, it says you can only rent once a year for no shorter period than 12 months. That is going to be in conflict with the inference that it's an unrestricted rental based on your governing document, the declaration. So in that instance, you need to put it in as an amendment to the declaration. Now, some declarations will have rental restrictions, and then we'll have a provision to authorize the board by rule to make other restrictions. So in that instance, you'll be able to, tweak your rules. And the last level of the test is the rule has to be reasonable. And I always add on its face and in its application. So you can't put something in that says no rental for longer than a week. That probably would not be reasonable.
No. But I'm sure there are people who try to do that, though. Okay, let's go to. We're going to go to our final break, and we come back. Let's just go over some of your classes again. Yes. We come back. If you'd like to give us a call here, it's 888-565-1470. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with K. Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, K. Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert K., Michael Bender, and Jeffrey Rembaum, K. Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we are back. We're back for our final about 10, 12 minutes. We're with Robert K. Bender Rembaum. They're community association lawyers. They cover all of South Florida, actually all of Florida they could, but mainly here in Broward and Dade and Palm Beach, Martin County, and just opened up a new office in Tampa. That's a great market,
Not
by
just,
the way.
It was April, but yeah, it's relatively new.
Well, compared to how long you've been in business for.
Well, that's true.
It's pretty new. You've got some classes coming up.
We do. In our Pompano office, we have condominium board member certification this coming Tuesday at 6:30 to 8:30. That's the only class we're going to be doing in Pompano this month. We will pick up again in January with some interesting classes on fair housing and assistance animals and board member certification, as well as Ask the Attorneys that will be in
My favorite.
the South County Civic Center in Delray on January the 9th. At 11 a.m., it's going to have some food there for lunch, so that's a good one.
Always do.
And all of these can be registered at registerkbr.com for online registration. It's a good idea to RSVP to all of these because space is limited and there's food, so we want to make sure we have enough. On Wednesday, December 11th at 3 p.m. in our Palm Beach Gardens office, we'll be doing the condominium board member certification at 3 to 5:30. And then on December 18th, again at 3 to 5:30, board member certification for homeowners associations. And then that evening at 6 p.m. in Palm Beach Gardens is an interesting one from 6 to 7:30, board member and officer liability insurance policies. You think you're covered, think again. So that's a very important one, but there is limited space. So we do, again, suggest register with us online, registerkbr.com.
Great. Hey, we have a caller. Let's go to our caller, Kelly. Hi, Kelly.
Hey, hi, how are you?
Good.
Hello, Kelly.
Good. Hey, I have a question. Can my HOA fine me for watering my lawn if the city water rules allows X amount or so much amount of watering per week, and I'm within that? Can my HOA still fine me?
Well, the HOA can fine you for violations of the covenants and rules within your community. They wouldn't be dealing with any municipal ordinances. So if your association has a limitation on watering within your documents, then it is possible that they could fine you for that violation. Now, whether or not that's a truly enforceable restriction will depend on what it says and what the limitations are and whether it's in your covenants or rules. And there's a little bit of an analysis that we would want to put it through to see if it's an appropriate restriction. But in concept, the answer is yes, it could happen.
Okay, thank you.
Okay.
Thanks, Kelly. We had one of our emails. They're a small community that back up to two large communities. And they want to know if they can, I guess, incorporate into their HOA.
They want to combine?
Combine.
Well, that can be tricky. There's different ways to go about that. If there are these two communities and they want to merge them all into one
Right.
and make it one
They
big
feel
community,
like it'll save them money.
it depends on whether they're just having one association that governs the three or they're making it one community. They're different in how that works. If they want to merge it all together and make it one big community, that's going to likely require the approval of all of the unit owners, 100%.
100%,
Plus
okay.
mortgagees. So that can be a very involved and difficult process. And I've seen it done, but the larger the communities, the more number of homes, the more difficult it can be. One time there was a association client of ours that had 6 different condominiums with one association, 360 units. They got the approval of 359 of them. And,
You're kidding.
they had one holdout and ended up having to go to court to get that resolved, and ultimately did. But it
One
can be
held it up, though.
for political purposes, and so that's always an issue as well. The other alternative is sometimes it can streamline by having a single corporation that's operating the 3 separate communities that may have some common facilities, or they'll create some common facilities for them. That would be a lower percentage, whatever it takes, the highest percentage to amend any of the governing documents would be the number then, because you would have to do amendments to tie that all together.
I was kind of surprised it wasn't about, them using the golf course or tennis courts. It was about it would save them money.
The likelihood of that actually occurring is pretty low.
Is it? Okay.
Yeah.
Okay. We kind of talked about this because a lot of the boards are going to be voting, and this lady said process of counting votes for the board where the condo owners can't complain afterwards. I guess she's probably had problems in the past.
Well, if anyone's been involved in condominiums, it's pretty rare for there to be anything to happen without somebody complaining. So you can't please everybody, and you're not going to.
Is this done behind closed doors?
It's not supposed to be behind closed doors. And condominium elections have been specifically set forth in the statute since 1992 in a manner that is different from your general corporate elections as HOAs typically are. Within condominiums, there's a requirement of first notice of 60 days to be sent to all owners of the upcoming election and an invitation to submit themselves as a candidate to run for the board. There's so many seats, and you have until a specified date, which is 40 days before the election, to submit your notice of intent to run for the board. If it comes on the 39th day, you're out. You can't run. So that's an important timing. Once everyone submitted their names, then within typically 35 to 30 days, the board then has to send out a second notice with a ballot. And within the ballot, there's about inner envelope that the ballot goes into, and then the inner envelope is sealed, and that goes into an outer envelope that is also sealed with the information of the unit so that the voting is secret. And then that is either mailed or hand-delivered to the association prior to the election. At the election itself, the process that is supposed to be followed is that the first order of business is the election, is counting the ballots. And there's a process that you have to go through. The first step, once you've ascertained that all the ballots are properly from unit owners and you've identified the units and logged them in, you have to first separate the inner envelope from the outer envelope and set the outer envelopes aside, but keep them. You have to keep all these records, at least for a year. And then you have to then cut open the inner envelopes, take out the ballot. If there's more than one ballot in an envelope, that's a problem. So you have to be careful about that. Only one envelope per ballot. And so you separate the ballots from the inner envelope, set the inner envelope aside, keep those. Depending on how large the community is, you may have multiple groups of volunteers for the counting, but then you go through and you tabulate all of the ballots that you've received, and it's all to be done where people can watch, and it can take quite a long time. So that's the general process, and then you announce who the winners are and go through the rest of your meeting. The Ombudsman's Office within the Department of Business and Professional Regulation will send a representative to handle that aspect of your election upon the petitioning of at least 10% of the owners. In that instance, the association's going to have to pay for whatever the costs are for that service to be provided. There's also outside companies that will do that for a fee, and hopefully that would provide the neutrality that the complaining owners may be thinking they're missing.
Wow. I did not know was that involved. Give everybody the phone number.
K. Bender Rembam can be reached at 800-974-0680. We're at kbrlegal.com. You can send us an email at info@kbrlegal.com. Register for classes at registerkbr.com. Go on our website. There's a calendar of events. You can see upcoming classes and locations as well.
Do you go out to associate the condo or
we will,
HOA associations
we'll go to
make
some,
a presentation?
Absolutely.
Okay.
No charge for that.
Very good. Hey, I love doing the show with you. We're going to be back on Monday, 6 to 7, with more Ask the Experts. and we will see you soon down the road.
See you next month.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O.